Good morning, everyone, and welcome. We're just going to wait a couple of minutes to give everyone a chance to log in. So just relax and be patient, and we'll get started soon. Okay, well, hopefully everyone's had a chance to log on. If not, I'm sure there's a little time while we're going through our introductions. And just welcome to an inside look at the June 2025 policy packet webinar, where we'll be highlighting some of the policies that we updated in our June packet. Next slide, please. So just a little bit about our agenda for today. We will first have some housekeeping and presenter introductions, then a practice poll and a quote unquote real poll. Then we'll have a little bit of a gamut overview onto then our policy updates with some time for questions and answers. We'll have a second poll where you get the chance to evaluate us. And then at the end, we'll have some time for additional questions. Next slide, please. So a little bit about housekeeping. In terms of questions and answers, please use the Q&A feature to submit your questions. You could see from the visual where it's located, and the chat feature has been turned off. So this is the place for the questions and answers to go. And the questions will be answered either live or in writing. So live will be by our presenters and otherwise through the Q&A feature. And all attendees will receive a link to the video of this webinar as well as the slide deck. So you don't have to worry about that or taking notes or if you feel like you're missing something, because we will be able to provide that to you. Next slide, please. So a little bit for introductions. I am Barbara Leifman, and I'm the Director of Policy Manual Development. And I would like to also introduce Kristen Lindgren-Bruzon, who's our General Counsel, Dustin Bindriff, who's our Senior Policy Manual Writer, Tazita Stewarts, who's our Senior Director of Policy and Governance Technology Services, and Josh Daniels, who's the Chief of Policy and Governance Technology Services. Next slide, please. So we're going to start with a really fun, well, I hope it's really fun practice poll, just to make sure kind of everyone knows what we're doing in terms of the polls before we get into our first formal poll. So we thought it would be fun, a little bit of a summer theme about what is your favorite summer cool down treat? A, ice cream by far. I love the creamy taste. B, popsicles. The cold crisp sweetness is irresistible. Or C, neither. I prefer a dive into the swimming pool. So let's take just about 1 minute to put your selection in, and then we will look at the results. Okay, let's take a look at the results. So it looks like ice cream is the winner, followed by swimming, going into the swimming pool, and then popsicle seems to be the last. Okay, so next slide, please. So this first poll is about composition of who's attending the webinars, and it's really important for us because we try, our hardest to serve you well by creating the correct focus to the webinar. So let's look at our first question, which is, have you previously attended one or more update webinars? A, no, this is my first one. B, yes, I have previously attended one or two. C, yes, I have previously attended 3 or more. And then there's a second part too. What is your role in your district or county office of education? A, board member. B, superintendent or administrator. C, executive assistant. Or D, other. So let's just take a little bit to for everyone to submit their choices. and then we will look at the results. Okay, why don't we take a look and see where we all stand? Okay, so it looks like for many, this is the first webinar. And then people who've previously attended 3 or more. And then the least amount is previously attended 1 or 2. And then in terms of role in the district or county office of education, we have most are executive assistants, which has been typical, then followed by superintendents or administrators, and lastly, board members. But we are happy to see that there is more participation by board members than before. So that's great. Next slide, please. So I'm going to now introduce Tazita Stewarts, who's going to do a little explanation about using Gamma to access the update packets.
Thanks, Barbara. Good morning, everyone. And to the 50% of you who have not attended a webinar previously, we're just going to overview how you access the update packets, and then we'll move into a conversation about the contents. So next slide, please. Essentially, there are 2 ways to access the update packets. One via the Gamut policy site, also known as the sample site. And so this is for districts and LEAs who do not have their own Policy Plus page that hosts their own district or county office manual. You'll notice that the site looks a little different when you log in. Once you're logged in, you'll be able to see your name in the top right-hand corner, and that's how you'll know that you are logged in correctly. And then you'll select the correct manual. So you want to make sure you're clicking on district or county office manual. So the page that you see in front of you is just identifying where you'll click to get to the policy updates. There's a menu bar in the top right-hand corner, and you'll select policies and then policy updates, and that'll get you to the right place. Again, this is for policy only subscribers. If you have a Policy Plus site, next slide, please. You're going to navigate to a different page. That page is going to reflect, next slide, please, the Policy Plus site. So that will be the identifier in the top corner. It's going to indicate your district or county office name. You can go to the next slide. And the Policy Plus site that's unique to your district or county office of education is going to look, again, a little different than our sample site. But same menu bar in the top right-hand corner, you're going to go to policies and then go to CSBA communications. From CSBA communications, you'll see that the packets are organized by the month and year that they were published. And then the most recent one will always be the first one that you'll see, either all the way at the top or all the way at the bottom, depending on how it's sorted. And then you're going to click on that link, and that's going to take you to all of the attachments, as well as the associated documents with each update packet. Next slide. So if you are a county office of education, again, that'll look a little different, but there's really no difference in how you access the document. You're going to go to the policies communication section and select the link that says county update packet. Excuse me. Next slide, please. So we are a team of about 4 on the support side. And so if you ever have questions about how to access your policies, how to navigate to the sections that we referenced earlier, or what services you have, or you want to get some more details about how to make the system function a little bit better for you, you can always attend our drop-in sessions. Those happen every single Wednesday at 2 p.m. In order to get the link to those sessions, you just need to go to the csba.org/webinars link, and there'll be a link to register for each week, and you can put your information in there, and you can ask questions. Usually there's not a topic specifically that we're focusing on, but you can ask and have any questions answered about technical system things, or if you want a more detailed training, you could also request it at that time. Next slide, please. So there are a couple policy services that we offer for districts or LEAs who have found themselves in a situation where they are a little bit out of date. Maybe you've missed a couple of update packets, maybe you've had recent turnover in staff, and you're wanting to kind of catch up. The 2 options that we have are a policy manual review and a policy development workshop. The policy manual review is just a report. At the end of it, you'll get a kind of snapshot or an at a glance of where your LEA is in terms of being in alignment with the CSBA samples. The policy development workshop is the more in-depth, detailed workshop, and really it's a way to bring your district or LEA manual all the way up to date to be in alignment with the CSBA samples. And so if you're interested in either of those services, the first step would always be to reach out to our Gamut team. You can do that at gamut@csba.org. I believe we have a slide with contact information, but if anyone has questions about how or when or what you would need to do to qualify for either service, you can always put that in the Q&A and I can follow up. Next slide, please. So the last thing I'll say about Gamut is that it's a system that works best when you're using all the modules together. If you are a Gamut Policy or Policy Plus user and you're not yet aware of or using anything beyond that, we'd really like the opportunity to talk to you about ways to make the system a little more functional for you, to help streamline your processes internally and make sure that your meetings, agendas, and minutes are made available to the public in the most efficient way possible. So our Gamut meeting service is available independent of Gamut Policy or Policy Plus, but it also makes a great addition to both of those services. So some of the key features of our meeting sites are that you can search through all of your meetings using keyword search. That's all in one location, so your public or your community or your staff don't have to go to different sites in order to understand what's happening across both modules. So that's policy and meetings. And then you can access it from anywhere. So if you have questions about the Gamut Meetings service, you can always reach out to our team at gamut@csba.org, or you can message in the chat and we'd be happy to follow up with you. Next slide. And then we're going to shift over to my colleagues. But again, as I mentioned, if you have any questions about the policies or the services, we'd be happy to talk with you further. Thanks, Barbara.
Thank you so much, Tazita. Okay, so before we get into the heart of our webinar, we're going to talk a little bit about the basics of the sample policy. Next slide, please. So a little bit of things to know. You're probably aware that the board legislates by way of board policies, and this is the way that boards can set direction or for either their district or county office of education. Then we have administrative regulations, which is really like an implementation tool that the superintendent and other staff can use. And it provides necessary details, but they also coordinate and stay within the confines of the board policy. So the board policy is still the overreaching document, and then the administrative regulation would fall within that. There is a little bit of a caveat for county superintendents. It might not apply the same way or analogously as to districts, just because of the different dynamic between county boards and county superintendents in certain jurisdictions. We also have exhibits, which provide forms, notices, and other implementation tools. And again, consistent with the BP and of course the regulation, if that exists with that particular number of policy. And then there are also board bylaws, which are specific policies that provide rules and procedures that the governing board itself must follow. So they structure the governance of the governing board. So policies also is an inclusive term for the board policies, the regulations, the exhibits, and the board bylaws, all of these documents that I just described. And it's important to know whether during this webinar or other interactions with CSBA that we will sometimes use the inclusive term policy, and we might be referring to any one of these documents if we're not being specific about a particular one. Next slide, please. So the way we're structured, the sample policies are structured, are with a numbering system, and it ranges from zeros to the 9,000s. And it's kind of self-explanatory from the slide. Just a couple of things I wanted to point out. One is the 2000s. So again, applicable only to districts, again, because of the different dynamics between county boards and county superintendents compared to district boards and district superintendents. The 4000s get a little confusing because we have different categories depending on if it's certificated, classified, or supervisorial managerial staff. So the 4100s are for certificated, 4200s for classified, 4300s are for the supervisorial or managerial. And to add a little more complexity, sometimes they are similar, like exact language, where we call them double coded or triple coded, meaning that even for the different categories of staff, the same document works for all, either works for two or works for three. Sometimes not, sometimes they're individual. And the ones that start with a 4-0, again, would apply to all three types of staff. And then, of course, you'll see the 9,000s of the board bylaws. We did specifically leave the 8,000s blank just in case. So it gives us a little wiggle room. There are over 800 sample policy documents. So if we're counting the document itself, over 800, going by the code numbers, since I mentioned before, some have BPs, ARs, exhibits. There are less code numbers. So, but still many, 550 plus code numbers, and most have a board policy, some just have an AR, and again, some have exhibits too. Next slide, please. So again, we talked about policies as a collective word for referencing any of these four types of documents. And keep in mind that they are samples, and the ideas for these to serve as a starting point for your districts and county offices of education, and to review it. And when you do review it, to think of the ways you can customize it to the needs and context of your district or county office, including ways that you can really maybe help shine things you're very proud of, or if there's other places you have concerns, you can be a little more restrictive, assuming it's all in accordance with law. So it's really a place that you as a board and as a district or county office can customize and make it very personal to your, really the personality of your jurisdiction. So the policies do go through extensive legal review. In fact, from beginning to end, our writing cycle takes about 3 months from when we start drafting to when we publish the policies, or now post them. Please keep in mind that they do not constitute legal advice, and they may become quickly out of date. So we always recommend with all policies that you have your legal counsel or CSBA's district and county office of education legal services review for your particular district or county office of education. And also important to keep in mind that any changes we make, we kind of have a cutoff about 2 weeks before the publication date. So especially in times like now where the law and a lot of other guidance is coming out very frequently, and there's a lot of influx type of issues arising, it's very important to check with your legal counsel, probably more important now than ever. One more thing to know is that notes are embedded to provide context and additional guidance, and they can be seen depending on what you honestly, kind of what Orbit to Zeta was handling, what you click on when you go to look at the document. Just to know, they can be provided to board members, but should not be included in the adopted version of the policy. They're really just meant for an understanding and description, and hopefully so that you as board members and executive assistants and administrators can understand the content of the policy as well as possible. Next slide, please. So we will go on to our June 2025 policy update packet highlights. Next slide, please. And we structured this webinar a little bit differently, more like how we did our last webinar, where we're going to be highlighting a couple of topics. Oh, here we go. So we're going to be highlighting artificial intelligence policies, and we're also going to be highlighting Title IX policies. Then we're going to go on to the other policies, or a selection of some of the other policies that we worked on. So I am now going to hand it over to Josh to start us on a discussion of artificial intelligence. Before that, this is just a little look at the other policies that we did update as part of our June packet. Okay, next slide, please. And here we go. So Josh, please take it away with artificial intelligence.
All right, thanks, Barbara. So we're going to cover two policies, 0440, the District Technology Plan, and 0441, Artificial Intelligence. We have updated 0440 and 0441 as a new policy. There are also county office versions, unique county office versions of each that have been written with county offices specifically in mind. So the title for 0440 for county office is going to be different. It's not going to be District Technology Plan, but we're just going to use that one for purpose of explaining it, but the content is functionally the same. So this is part of sort of a larger effort at AI that CSBA has been engaging in. There's an AI task force that operated for a couple of years. And overall, sort of though the sort of the foundational considerations and principles that came from that task force has informed aspects of the AI related policies. So, overall, obviously, I think it goes without saying, but we'll say anyway that AI has great potential to benefit and to harm, and it is already widely used. And so that second fact was important in how CSBA looks at this, which is that it's already out there. It's kind of hard to put the back in the bottle or whatever the phrase is. So from a sort of a policy perspective, there were two options that were considered. Option A is where you permit the use of AI, sort of, but subject to certain constraints or restrictions, caveats. The other is that you prohibit AI, subject to certain permissions and caveats. So ultimately, CSB went with option A. So that is to permit the use of AI, but then sort of pull it back with a certain number of restrictions and caveats. And for students, it was all about, whether or not the use of technology, the use of AI, prevents or inhibits students from achieving the district's or county office's academic standards. So that is, that sort of is the general caveat. And then for employees, it's that employees must review and be responsible for the final product itself. So those are sort of, there's a few more in there, but those are the main sort of pullbacks, from generally speaking, sort of how we have approached the use of technology and the use of AI in particular. So with respect to 0440 specifically, obviously this was a policy that talked about the district's technology plan or the county office's technology plan, which went way beyond AI. And originally, it was drafted because CDE was requiring districts to create these technology plans. This was, like 15 years ago or something like that. So it's a fairly old requirement, and that was really what the administrative regulation focused on. So we actually deleted that. We just deleted the AR entirely. Some of the substantive aspects we incorporated into the BP, but now that so that if you as an LEA have a technology plan or want to have a technology plan, this would be the policy for the board to adopt. And therefore, it requires that a technology plan exist, but the authority for that requirement is based upon the board's authority, not this requirement from CDE. So the BP was rewritten with that in mind. Um, it adds language about wanting the plan to align with the goals, objectives, standards, and safe use and other aspects, of sort of the district sort of foundational documents. Also want to make sure that it aligns with the use of AI, how the district imagines AI should be used. Um, it does include a list of components that should be included in your technology plan. So take a look at that because it may not be the list that you want for your district. And again, because this is coming from board authority rather than CDE, LEAs have a very wide range of what those components would be. So this list is sort of informed by the past, but certainly should be modified to fit your local needs and contexts. And then there was a sort of in the beginning, there was an acknowledgement about the potential negative consequences of technology resources. It already mentioned positive benefits, but this was about sort of the negative piece. Um, and then we have 0441. So this is a brand new policy. This was created in response to numerous requests for a specific AI dedicated policy. There were a number of other policies that have been updated with AI in mind, particularly the academic honesty policy. But because there was such a strong demand, we created this policy sort of in response. And it primarily lays out principles for the use of AI. Must be student-centered, staff-centered. There must be ethical use and transparency, accountability and responsibility, equity and access. It needs to be secure and private. There needs to be PD associated with it, so you're not just rolling it out without any support. You must engage your community around how you're going to use AI, what's prohibited, what's permitted. And then there must be sort of continuous improvement and reflection and evaluation about how it is used by students and staff so that you can adopt, sort of adjust your policies, procedures PD, etc., to align with the best practices and evolving technologies. We don't know what's going to AI will look like in a year or two or five, and so making sure that it doesn't, this policy doesn't is not static, right? That it adjusts. Um, the policy itself, obviously, and some of the slides goes into a bit more detail in each one, and these principles should be adjusted again to fit your local needs and context. Um, these were the ones that sort of came out of the task force and sort of made sense to CSBA, but they're not, unlike most of our policies, these principles are not required by law. This is something that sort of came out of another context. So there are other policies that are AI related that we have updated with that in mind, and I'm not going to go over them. I'm just going to mention them in passing, and we're going to send out the recording of this and the slides. So if you're interested, the slides are here for you to review. There's a 4040 employee use of technology. That actually was covered in the September webinar of last year. The one I mentioned before, academic honesty, 5131.9, that was covered a year and a half ago or so in September of 23. Student use of technology, 6163.4, again, was covered in the September webinar of 2024. Homework and makeup work and student assessment, these two policies were also covered 2 Septembers ago in 2023. And again, all of these were the bullets on these slides pull basically the same content that we covered in those webinars. So you can go back and look at those if you're interested, or you can just, pull up these slides and go from there. But all of those other policies are updated. So these are the two policies. And again, we have the other five. So in total, we have about 7 AI related policies. We sort of consider that sort of a mini AI policy packet. It's not being released sort of separately, but if you're interested in bringing to your board sort of a comprehensive sort of set of AI related policies, it would be these 7. So the 2 that we just updated, and then the other ones that I just covered. Okay, we have now time for some questions. If you want to throw some in the Q&A, you can ask them now, or you can think about it as we go forward with the webinar, and you can ask, still put them in the Q&A, and we'll get to them, later on in the webinar.
Thanks so much, Josh. So far, I don't see any questions that have come through for artificial intelligence on the topic of AI. So why don't we move on to Title IX, just in the interest of time? But please know that if you do have questions about AI, to please put them into the Q&A feature, and we will get to them. We can either, we'll see, depending on how our timing is working, we can either do it after our Title IX presentation, because we are going to do Q&As at that point, or at the very end of our whole webinar presentation. We're going to be doing more questions and answers too, as you saw from the agenda we outlined at the beginning. So listed right here are our policies that we updated because of Title IX. You'll see that they are not just Title IX policies. It can be a little confusing. They are impacted by changes to Title IX, but of course cover a gamut of things, including general non-discrimination, which includes things other than Title IX. Also, UCP, as you know, is a process much greater than whether Title IX does or does not impact it, and so forth with a lot of the rest of these. Some are focused specifically on Title IX, such as the Title IX sexual harassment complaint procedures. So next slide, please. And with this slide, I'm going to turn it over to Kristen, our general counsel, who is going to start us off with a discussion on Title IX.
Hi, everybody. I'm happy to be here. As Barbara noted, I'm Kristen Lindgren-Berzoni. I'm CSBA's general counsel. Just to dive right into it, I'm sure you're all aware of kind of the back and forth changes of Title IX, but just in case, Title IX is a statute that was enacted in 1972, part of the Education Amendments of 1972, signed into law by President Nixon. And it, as noted on the slide, it is intended to provide protection from discrimination based on sex in programs or activities of educational institutions that receive federal funding. And you often hear Title IX discussed as far as athletics and making sure that female students, women have the same access to athletics as the boys teams, right? And there are sufficient teams for women to participate in. It goes much farther than that though, and protects against sexual harassment and other forms of discrimination. But we'll talk about how the regulations that are at issue here are limited to sexual harassment at this point. So we have the citation for both the statute and the regulations here in the slide. And the status changes pretty regularly and has been kind of going back and forth based on which administration is in office at the time. So the Biden administration enacted new Title IX regulations, amending those that the first Trump administration enacted in 2022. And the regulations process takes quite a bit of time. They have to be written and then they have to go through public comment period. So they were not issued until April 2024, towards the end of the Biden administration. And they took effect August 1st, 2024. So we are not that far away, not even a year out from when those took effect. But when just after the election and right before President Trump was inaugurated for his second term, a judge in Tennessee and the district court, the federal district court, issued an opinion, I believe it was January 9th, so it was really right before the inauguration, that vacated Biden's 2024 regulation. And so typically, if Biden were to have served another term, or even if Harris had been elected, they may have appealed that decision, but they did not. The Department of Education at that time accepted the decision because they were going out within a couple of weeks. And obviously the Trump administration did not appeal this decision itself. So we are now back under the 2020 regulations. And we'll talk about, there's kind of a period of time where you were under the 2024 regulations. We'll talk about that in a bit. But that's where we are now. The Department of Education will enforce based on the regulations that were effective August 14th, 2020. So you may remember, please. You may remember that we issued a pretty large, just waiting for this slide to click forward. Thank you. We issued a pretty large special packet back last July to update the policies based on those 2024 Biden regulations. It required quite a bit of editing because of the policies referring to each other, but so we issued a number of updated policies. And while we were doing that, went ahead and made other needed updates that were unrelated to the change to the regulations. So this is important for kind of where we are now. So we have given Tennessee versus Cardona and the current OCR guidance to use the 2020 regulations. We have now updated the policies again to go back to the 2020 regulations. However, to the extent we made other changes based on state and federal law and guidance documents that were required but not part of the new regulations, we left those changes to the extent that they are still good law. So it didn't revert. It would have been nice, right, to just revert right back to where we were before, but we couldn't do that because we didn't want to remove those other important updates. So they're not exactly the same, the policies, as they were effective with the 2020 regulations, but they do go back to the 2020 regulations insofar as we needed to revise to go back to that. And we removed any outdated guidance documents that may have been related to the new regulations or were otherwise just outdated based on current law. So that's where we are with the policies. We wanted to go over just some key foundational differences. So next slide, please. So there are certain protections that were included in the 2024 regulations, but not in the 2020 regulations. I'm going to talk about it a little bit in the next slide, but there's a difference between the 2024 regulations protected against discrimination on the basis of sex, not just with respect to harassment, but the 2020 regulations really only deal with harassment allegations. So that's one change. The 2024 regulations also included protections for sexual orientation, gender identity, gender expression, and other sex stereotypes. And that was part of the litigation in the Tennessee versus Cardona case. The judge stated that they exceeded their authority by including that in the regulations. And part of that is because the Supreme Court has said that the definition of sex in Title VII, which is a employment statute, does include all of those protections, but the judge read Title IX differently. So that's kind of how the law is sitting right now federally. However, California law provides all of those protections. And so we need to make sure that everything that we're doing is compliant with both state and federal law. And so we have included those requirements, and there are some complaints that would have fallen under the federal process in the 2024 regulations that will not fall under the federal process in the 2020 regulations, but still must be addressed under California law. And usually that's going to be through your uniform complaint procedures. So this change to federal law might have had a more concrete or more significant change to states that don't have those protections already built into their own law. For California, it's really more affecting what process you use for complaints. And then we are aware of some executive orders and dear colleague letters that potentially conflict with state law. Those are being litigated in a number of cases. And so we have followed our practice that we have all done, which is that we do reference dear colleague letters when they are in effect. There is a current dear colleague letter out there that does reference some things related to Title IX that is currently enjoined and is not in effect. So just be aware of that. But we do, in general, as a practice, reference them in our policy notes where applicable. It is not our practice to rely on executive orders as a basis for legal requirements. And that, again, is a blanket practice. It's irrespective of who is issuing them. But that has been our practice. So while we do monitor those, this is another reminder to be checking in with your legal counsel, or if you'd like, use our District and County Office of Education and Legal Services as you're updating and adopting new policies. These are not substitute for legal advice, and you should always be checking with your legal counsel to make sure that you are creating and adopting policies that work for you. So just another reminder there. A couple other changes. The term sex was defined in the 2024 regulations, but not the 2020 regulations. So for purposes of our policies, we feel that you need a definition. So we're using definitions consistent with California law, our case law, and generally accepted terms within academia, just to make sure we're providing a definition that is useful. We also note that lactation accommodation was included in the 2024 regulations. So there was a requirement to accommodate lactating students. And that is not in the 2020 regulations. However, California law requires lactation accommodation for certain groups, both students and employees. So again, reminder to follow state law in that area, and our policies are reflective of that state law. Okay, next slide. So as I noted, the 2024 regulations required grievance procedures for complaints alleging either sexual harassment, it was called sex-based harassment, or sex discrimination, which is different from harassment. It means treating somebody differently on the basis of a protected classification versus verbal, visual, and physical conduct that impacts a person's ability to participate in the educational program. That's the difference between discrimination and harassment. So those were both covered by the grievance procedures that are set out in the regulations, but the regulations only apply to sexual harassment as defined in those regulations. And Title IX, we have the regulation citation there for you. And so, well, what does that mean for that period of time where the 2024 regulations were in effect? So between August 14th, 2020, when the first regulations went into effect, and July 31st, 2024, you use the 2020 regulations. And then after January 9th, when the court vacated the 2024 regulations, you use the 2020 regulations. And this is for conduct or allegations that occurred during those periods. If there are allegations in a complaint of conduct that occurred while the 2024 regulations were in effect, consult your legal counsel. It is a gray area of the law, which regulations you should be using, because technically those 2024 regulations were in effect during that period of time. And then to the extent you have complaints alleging sex discrimination, which is again not covered by the current enforced regulations, or sexual harassment that doesn't amount to sexual harassment as defined in Title IX, then you use BP and AR 1312.3, your uniform complaint procedures, and Administrative Regulation 4030 for employees. So what does that mean? The definition of harassment in the 2020 regulations is not as broad as the California definition of harassment. So you may have a complaint that does not fit the Title IX regulations, is not required to be handled pursuant to those grievance procedures, but it doesn't mean that you don't have to address it, because under California law you do. So it is really a selection of which complaint procedure you use that is at issue. There may be states that do not have a broader definition of sexual harassment and that only ever need to follow the Title IX grievance procedures. But that is not the case in California, because we have a broader definition. And again, this is a time to talk with your outside investigator and your legal counsel to determine which complaints have to follow which grievance procedure. And just, as a note, for example, in the 2020 regulations, harassment is that which is conduct which is severe and pervasive. So a high level and also over a pattern over a period of time. In the 2024 regulations, it was severe or pervasive, which meant that lower level conduct could still constitute sexual harassment, even if, or so long as there was a pattern of it. So you can already see that it was a much lower standard in 2024, so more complaints would have fallen under the Title IX grievance procedures. Okay, next slide, please. And then just to be aware, and I think Barbara, maybe this is more for you to discuss, but we had some movement of policy language just related to these changes. So go ahead.
Sure. Thanks so much, Kristen. So yes, just wanted to talk very briefly about movement of policy language. I don't know if you recall, but when we did our update in July, we moved some material so that to kind of align with the regulations in 2024, that sex discrimination and sex-based harassment were kind of blended together. And both had to follow the Title IX grievance procedures. So we separated that out into our policy materials. So we took sex discrimination out of 5145.3 and out of 4030, which is our general non-discrimination policies for students and employees, and moved it into 5145.7 and 4119.11, and that's triple coded, so we don't need to read them all off. But we had moved that into the sexual harassment policies, and they were renamed, which I'll get into a little bit later. Well, now we have moved them back. So sexual harassment is back in 5145.3, as well as back in 4030. We did clarify too in almost all of the policies that the list of actual perceived characteristics that may serve as basis for unlawful discrimination in education programs and activities. And we have cited all of the legal sources for those actual perceived characteristics, just to make it very clear, especially since the 2020 regulations, which we are back to, do not clarify it as the 2024 regulations did. So again, though, this would be on, based on state law as well as some federal law, not always Title IX law. And again, it's not just Title IX discrimination. It could be all forms of discrimination, including religious, race, ethnicity, immigration status, all of that. So, okay, next slide, please. And here are for the changes to the policy titles. So in keeping with what I said before about how the movement of material went back, sex discrimination went back into our general non-discrimination, we again renamed our sexual harassment policy to be sexual harassment. It had previously been sex discrimination and sex-based harassment, both to show that sex discrimination was covered that way and to use the more general term sex-based harassment, which was required under the 2024 regs. And then we also, for the grievance procedures too, we went back to our name we had previously, which was Title IX Sexual Harassment Complaint Procedures, again, taking out the sex discrimination and sex-based harassment complaint procedures concept, because that is really a concept of the 2024 regs. Next slide, please.
Barbara, there was just a question in the Q&A to go back and just repeat again what you moved and then move back.
Sure. So what we moved is, let me try to make this as clear as possible. Well, let's start. So there's an employee policy and there's a student policy. The employee one is 4030 and the student one is 5145.3. So I'm just going to say where it is now. So I think that'll be, I think that's probably the question. So sexual harassment is now back into 5145.3 and into 4030. It is no longer in 5145.7 or the triple coded 4119.11. I hope does that clarify it? I hope whoever asked the question.
We can keep going, and if there's more questions about it, we'll go back.
Okay, it is confusing though, and that's why we're trying to lay it out here. Looking at the slide itself might help when you go back or go back to study this a little bit more with your districts. So we also made some other changes to our policies based on changes in law other than Title IX, as we did with the July 2024 special packet. Again, we did that with this packet because more new stuff is out. So there's AB 3074, excuse me, which has two parts to it, really three parts to it. There was already a rule that public schools could not use the term Redskins as school or athletic team names, mascots, or nicknames. This law does provide an exception for those schools that are operated by an Indian tribe or tribal organization. The law also expands an expanded prohibition starting July 1, 2026 to prohibit public schools from using derogatory Native American terms for school or athletic team names, mascots, or nicknames without the written consent of locally, federally recognized tribes. Again, there is an exception for schools operated by Indian tribes or tribal organizations. And there's a third component which requires the use of UCP, the Uniform Complaint Procedures, to resolve complaints related to school or athletic teams' names, mascots, or nicknames. So that July 1st, 2026 date is important for that. There was also SB 939, which has certain posting requirements for related to neurodiversity. Next slide, please. There's SB 1100, which makes it an unlawful employment practice to include statement in job advertisement, posting application, or other material that the applicant is required to have a driver's license and that specified conditions are satisfied. And this obviously went into our employee non-discrimination policy. And then this one, SB 1137, this was covered in, I don't want to say every single one of the policies we listed as Title IX, but in quite a few of them. which provides that prohibited discrimination includes discrimination not because of one protected class under state law, but also because of a combination of two or more protected bases. Our policy materials pretty much had already said this, but we did clarify it and did substantiate it with the new law. So next slide, please. So here are time for questions on our non-discrimination and our Title IX policies. So let me look to see what we have in. And please, whoever asked the question about where the material exists, if I didn't clarify it enough, please let me know. So first question, what should a district do if California complies with the latest Education Department announcement regarding Title IX and CIF? Can a district immediately act upon that? Is a district allowed to amend its policies based on the Education Department's latest announcement? I guess that is a question for our district legal counsel. Kristen, do you want to start us off with this one?
Sure. So this just came out this morning. So we're aware of it. We're analyzing it. But it's not immediately clear the application of it. The state of California and other states have also filed preemptive litigation around this issue that's going to have to play out before there's really an answer here. But what I think is interesting is that while the Department of Education can take action based on funding, it can't tell a state that to repeal a statute. And California's statute does provide for students to participate in sex segregated activities on the basis of their gender identity. So that's kind of the legal piece that will have to play out. But I think someone asked if they should go to their district legal counsel, and yes, you should check in with your district legal counsel as you're adopting updated policies and get their take on it. That is the best way to proceed here. We're in a little bit of unprecedented times, so we're taking a look, but since this just came out a few hours ago, we don't have a specific answer at this point.
Okay, thanks, Kristen. So the next question, the AB 1266 FAQs were removed and no longer exist. I'm assuming they removed from CD's website. I'm adding that part in. Those were previously referenced in AB 5145.3 and 5145.7. Has that also been adjusted? And the answer is, you want to answer it, Kristen, or?
You can answer. It's up to
Sure,
you.
yeah, we did. We did make adjustments for that, and we were aware of that. So the policies that you have received recently should reflect that change. I don't know, Kristen, if you want to add more to that.
Nope.
Okay.
They're compliant with AB 1955, and again, always be checking with your own legal counsel as you're adopting new policies.
Okay, third question. Is there a way to get archive policy that was in existence prior to the 2024 policy update changes that our district completed? So that would have been the July, I'm assuming you mean the July 2024 special packet. It would help this district or county office to clarify the changes from 2020 policy compared to the new or the current policy update. So I guess this, I'm not sure, board member, administrator, executive assistant is asking, is there a way to compare the pre-special packet Title IX policies to the ones we just released in June, that we just released about a week or so ago? Tazita, you might have that information about how to access an archived policy.
Just have a follow-up question. Have they already adopted new language? If so, then yes, I can help you get access to the archived version of the policy. If you haven't yet adopted the new version, then the way to compare, we could talk about in detail, but I can follow up also in the chat to see if that's something we want to work with them on one-on-one, but there is a way to review archived documents. It's by clicking on, there's a little clock on the Gamut platform. When you adopted a new policy, if you click on that clock and you're logged in, you'd be able to see previous versioning if you've already adopted the new language. Hope that answers it, but I'll also check the chat to see if we need to follow up via email.
Perfect. Thank you so much, Tazita. Okay, it looks like so far the last question on Title IX would be, nope, more coming in, but let's handle this one. Do the new policies on sexual harassment define sex as male/female only?
I don't 100% understand the question, but I I would just say that California law still protects on the basis of gender identity and gender expression. So we have included those protections. Um, I think that's the answer, but I don't 100% understand the question.
Yeah. And then like Kristen is saying, and she said before, if it doesn't fall under a Title IX complaint, it would still mostly then go through UCP for students and through 4040 for employees. Okay, next question. The Education Department has found that Title IX, okay, so this is similar to the other question, but a little bit different, was violated for allowing trans athletes to compete. What does this mean? California law protects trans students. Does this fall under discrimination?
Yeah, I would just go back to my original answer to the question, which is that this just happened today. We're waiting to hear from CDE on their take. The state of Maine did settle on a similar case. I didn't mention this before. So there's a possibility of a settlement. So we're really just in wait and see mode. And if you're concerned about your policies, it's a good time to check in with your legal counsel.
And just to go back real quick, I added the definition of the term sex
Oh, thank you.
into the Q&A response. But as you pointed out, sexual harassment can be based on a lot of things. But in their policy, I'm just going to quote it: sex refers to the biological condition of being a male or female human being, and there's cites to the California regulation. There's a whole list of definitions in AR 5145.3. In case you're interested in what the other, how we define all of the various terms.
Thanks, Josh. Okay, next slide, please.
I think we want to, just because of the time, why don't we, there's a few other questions, we'll get to them at the end. But why don't we move on so that we can make sure to get to the rest of the slides.
Yeah, I think especially Josh might have been referring to the AI questions. Yeah, we will handle those at the end of our presentation. Okay, next slide, please. Okay, so I'm now going to hand it over to Dustin, who's going to cover some highlights from our other policies that we haven't covered yet. And then you'll see there's 4 here, and each has some unique characteristics about it. So Dustin, if you want to take over, would be great.
Thank you, Barbara. Next slide, please. We wanted to highlight BP and Exhibit 0420.41, Charter School Oversight. In particular, we moved the material revision section of this BP to Charter School Authorization, Board Policy 0420.4, as material revisions become a matter for charter authorization, not oversight. Additionally, due to the nature of how most legislation is now written, most all new legislation applies to charter schools. And so for that reason, we will not be updating the exhibit in the foreseeable future. If you do have questions about charter school oversight, please do reach out and we can refer you to a number of resources that can effectively offer guidance on charter oversight. Next slide, please. Regarding school bus drivers, and AR 3542 was updated to reflect the new specified qualifications and training requirements for all bus drivers. In addition, the regulation was updated to add to the list of required training for drivers, including training related to the district's transportation safety plan. Next, the regulation was updated to include additional requirements for drivers related to length of driving time, daily log sheets, and pre-trip inspections. Finally, the regulation was updated to add that the superintendent or designee shall retain records of school bus accidents for 12 months from the date of the accident. So we wanted to highlight these, and you may want to ensure your transportation department or staff is aware of the new requirements for school bus drivers. Next, we wanted to highlight, next slide, please, 6142.91. Here we updated this policy to clarify that the board will adopt instructional materials that meet or exceed Common Core standards. Next, we also wanted to add a section related to screening for the risk of reading difficulties. That this section provides for the required board adoption of screening instruments to assess students in grades K through 2 for reading difficulties, and to conduct those assessments and train the staff so they can administer those assessment instruments. So this is the dyslexia screening requirement in this policy. Next slide, please. Finally, we wanted to highlight Board Bylaw 9011 related to confidential and privileged information. Here we expanded and clarified the definition of confidential information, and we also expanded and clarified the potential board actions if a board member threatens or improperly discloses confidential information. Finally, we also clarified the conditions when limited disclosure is proper. Next slide, please, and I'll turn it back to you, Barbara.
Thanks so much, Dustin. So right here, you'll just see a list of the other policies that were part of the update packet. As you know, it was a really, really big packet that we haven't specifically talked about in today's presentation, but feel free if you have any questions on them, either now, either into the Q&A or we can either handle it in writing or orally, or at any other point, if you have a question on them, feel free to contact us. Next slide, please. So it's almost time for questions, but before we get there, just a couple more things. Next slide. One is how you would rate this webinar. It's very helpful to us. We are constantly trying to improve our services to benefit you more. So, we do value your opinion if you are finding these webinars helpful or not. So we're going to conduct one more poll. And if you could please rate if you find that the webinar was incredible, a 5, 4 for really helpful, 3 good enough, 2 barely okay, 1 not worth my time. We'll give just a few not a few minutes, just a little bit of time to answer. And then we'll find and look at our results. Okay, why don't we wrap up and look at what the results show? Okay, it looks like the majority felt that it was really helpful, so that's good. Then we go to good enough. I'm just making sure I get this right. Good enough. And 14% thought incredible. We do feel a couple barely okay. Hopefully we can get those higher next time, as well as our goal is to be in all 4s and 5s. So thanks
And
for participating.
I'll just add, particularly for those who are 3 or 3 or 2, if there are suggestions on how to, make it better, please, if you want to do it anonymously, that's fine. If you're comfortable, sharing directly, we certainly welcome the feedback. And we have a lot of different folks who attend these, and so trying to make it fit isn't always, doesn't always work out well. So, please, we certainly welcome the feedback, and are definitely open to making adjustments, if for those that are willing to share.
Okay, thanks, Josh. And next slide, please. So just a little bit of news that for those who have attended before, you probably know, we are going to shift our update publication dates a little bit. So the next policy update packet will still be as usual, which will be in September, sometime around mid-September. That'll be the September 2025 packet. Then after that, we're going to be shifting our updates to be basically 1 month earlier than they typically were. So it'll come out in November, February, May, and August, rather than the customary dates. And again, this was done based on user feedback as well as to better align with the school year calendar. Next slide, please. Okay, so we have a little bit of time, about 10 minutes for final Q&A. So let me see what else has come in. All right. Is there a way we can tell from the guide sheet or checklist if a 4,000 policy is double or triple coded? Yes, you should be able to tell from the guide sheet because it would have it listed, then it would numerically be listed there. Right above in bold, right above the summary itself, will have the number and the policy name. And there it should say, if it's triple coded, it will say like, let me use one of the Title IX ones for an example. It'll say like 4119.11 slash 4219.11 slash 4319.11 slash. So you will see that it's then that would mean that it's triple coded if you see that type of format. I believe it is also on the checklist you receive. Sometimes, like I said, it could be double coded where you would see two of them. Say you would see for one, this is just an example, 4119, 4319. That doesn't really exist, but just so you would see, and then 4219, say, would maybe be separate. So you should be able to tell from that. Okay, next question. For charter schools, are all authorizers still legally entitled to appoint one member to the boards of charter school that they oversee?
Would you like me to respond,
Oh.
Barbara?
Yeah, go ahead.
Sure, Dustin, if you're.
Oh, go ahead, Kristen. You certainly know more than me.
um, Education Code 47604C provides that a chartering authority that grants a charter to a charter school to be operated as or by a nonprofit public benefit corporation shall be entitled to a single representative on the board of directors of the nonprofit public benefit corporation. So it's not necessarily all, but a charter school that's operating as a nonprofit, you may have a member on the board. Whether you want to do that or not is something to discuss with your outside legal counsel.
Okay, next question. Was the student acceptable use agreement exhibit updated? Are they still necessary? So yeah, we did update both the student and the employee acceptable use agreement when we updated that policy. That was not part of this packet. I know Josh was keeping track on what packet we did that in, but yes, at the time it was updated. Then the question, are they still necessary? I know we recommend it. Josh, is that something required by law, the acceptable use agreement?
Not that there's no requirement for that specific kind of document that I'm aware of. It was updated, but certainly to enable to enforce it, it is common practice among districts that they have students sign it prior to using technology.
Thank you. Okay, and here is an AI question. Is there language to address when it's appropriate to cite AI when it is used to create documents? Is there consideration of when it is appropriate for students to use AI? For instance, is it appropriate for students in the primary grades to use versus secondary students? I guess, is there a more appropriate time for AI to be utilized like in elementary and middle school, high school?
Yeah, our policies don't drill down to that level of specificity in terms of elementary versus high school. That is one of the places where as you engage with the community and with your stakeholders to figure out sort of what makes the most sense for you, if there's a limit or certain access restrictions. In terms of yeah, I guess I wasn't sure in terms of the citing if it was more about like the research piece. Um, uh, but I would say that, the in the academic honesty policy, which we updated back in September of 2023, we use that phrase around, does it basically support or inhibit, a student learning the standards that you want them to learn. So, if it's something about how to write an essay, using AI to write your essay is probably not the best thing to do. But if it really is about, understanding and sort of sharing your analysis, and the analysis is done by the student and the AI supports that analysis, then, sort of using it more functionally may make sense. And determining when you would want a student to, cite that they used an AI. One of the things that we typically sort of ask in these contexts is, well, how often do you have students cite other forms of technology? And if you don't have them, say, cite the use of spell check or Grammarly, which you might want to have them do AI, but why are you asking that? What is the concern? To make really sure that your desire to have them message or note when they used AI is really connected to that need rather than just sort of a generic, oh, I don't know if I'm okay with this, and have them cite AI. Because in other forms of technology, we don't typically do that in those situations.
Okay, thank you. Question.
There's a
Who
few
is
more
generally
questions, Barb.
appointed? So there's more coming in. Okay. Who is generally appointed and could a school district board member be the representative? Chris, I don't know if you want to try to handle the follow-up to that.
Yeah, this is a question for your legal counsel. I think the trend has been not to appoint someone because then they become subject to all of the rules for a nonprofit board, which means they have to act in the best interest of the nonprofit board. So I think I would address that with your legal counsel.
Well, just to add, because I used to work in a district where we had a lot of charter schools, that was not the practice was not to appoint a board member just for the reasons that Kristen laid out. Because as a member of a nonprofit board, you have all of these fiduciary duties. You can't basically, you can't act as a spy for the school board because you can't reveal to your school board what was discussed in, say, closed session by the charter board or things of that nature. So. Um, what we did in that district was basically people that were thoughtful, that could be fair, and that understood their responsibilities to the charter school, legal responsibilities, um, because there were some restrictions on what they could sort of report back, quote unquote.
Yeah, and it's not an obligation. You don't need to sit on their board in order to have the waiver of liability that you get from doing oversight. So there's no obligation to do that.
Thank you. So Josh, are there more questions that I'm not seeing that have come in? Or we covered them
Nope.
all? Okay. Okay. Okay, so next slide, please. Okay, so just a big thank you to everyone for attending, and we hope that you found it helpful and meaningful and that you have a really good rest of your day.